I urge you again to tell me what is your argument on the entrapment ground.
Well, my argument on entrapment is that the entrapment that has been alleged, even by the report of the NCHR, that entrapment as such is not for the commission of an offence. That is only for the apprehension of the accused. So to apprehend the accused and to produce it for the accused.
Are you telling me that even assuming for a moment that there were women contacting some of the persons,
I do not agree with that.
I ask you to assume it. You don't have to agree with me to assume it. That if they were contacted by the women knew already that an offense had been committed. That would be your argument.
That would be my argument.
So that feeds into their case then. There is a distinction. How did those women know that an offense had already been committed under the blasphemy laws, so that they could now induce them to share that content with them?
Not that with respect to sharing of a blasphemous content is a separate point that has been given in the report. Now the question that you
are trying to create a distinction between inducement to commit a crime and entrapment, so that a criminal can be apprehended by the law enforcement agencies. Unless the private individual, a woman or a man, is already in the knowledge of the commission of that crime, right? He cannot possibly lead them to the criminal agency, and then it takes it out of the entrapment regime, because then he or she is simply meant to report it to the police. So I'm sorry, I don't even know how to write notes on your submission, counsel.
Not the submission that I'm trying to make before this on is that as one was argued before the lordship, the person appeared in person and argued before the lordship, that certain blasphemous content did appear before them on certain social media websites. So once that was there, thereafter that accused or the person who had committed this offense was contacted, and he was thereafter apprehended by the law enforcement agencies.
That is not a case before me at all. That is not a case before me at all. Then it's a simple case of XYZ learning from a social media account that blasphemy offense has been committed and simply reporting it to the CI. That is not the case before me. The case before me is that before the commission of the crime, people were induced to commit it. That's a separate. I think you need to revisit this ground, counsel. If you want to make submissions on it again, you can, but we will leave it for now. Move on to the next one.
The next point that I draw your kind attention is towards the digital and forensic analysis, because this was a query of this honorable court, that how digital and forensic analysis is done. The answer to this is very short. This forensic and digital analysis is done in light of the PICA rules, Chapter 6 of PICA rules, which were made, Schedule 6 of the PICA rules 2018. So the FIA basically
PICA rules
2018 Schedule 6. So if the case is given, the case is placed before the FIA, then they take out the digital and forensic analysis in light of the rules that are there. So because this was the query of the court that was asked on the last date of the hearing, so I'm just referring to that.
Can you show me this?
These rules are made under section 51 of the PICA Act.
This would be an interesting read. Please read paragraph 6.1 of Schedule 6.
No,
You don't have it?
no, that is the only copy.
And then we will do a joint reading of this later on. Yeah, yes. Acha.
Then my lord, moving thereafter is with respect to the literal rule of interpretation. My lord, if your lordship may kindly come to the prayer clause of the
Counsel, I think a lot of your colleagues are waiting for their cases to be called. I thought you would wrap it up in half an hour.
I am not taking more than
I must confess I took about 10 minutes or more of from your.
because I am on the last two ones.
Acha chaliye, please.
My lord, then if your lordship may kindly come to the prayer clause of the great petition. I call your attention to the very little rule of interpretation. I read it out. In light of the foregoing solutions, it is respectfully prayed that in the appropriate direction may very graciously be issued to respondent number 1, that is the federal government, to constitute a commission of inquiry under Section 3 of the Commission of Inquiry Act on the report of the special branch. There is no mention of any cases, but on the cases a commission has to be made. We are seeking a commission of inquiry upon the report that the special branch has put forth. So, if at all a commission is made, then that is to be made on the veracity of the report of the special branch, because that is what the prayer states. Nowhere in the prayer they have stated that the cases which are pending adjudication before different courts, that are to be dealt in a commission, or a commission is to be made upon that. And lastly, my lord, the very important question that has time and again been raised before.
Sorry, I am again interrupting you to understand what exactly is your point here. On the report of the special branch versus existing cases.
Versus existing cases. So, if
No, but on the report of the special branch, what are they going to look at? Because all the raw material for them to look at would be the existing cases. It won't be cases which are still not registered. How can the commission look into the future when the cases might be registered?
obviously it cannot. My argument would be that if at all a commission is made, then that is to see the veracity of the report of the special branch, not the cases that are pending adjudication of that activity. Because the petitioners are asking a commission on the report of the special branch.
Achha, आगे चलो.
Then why is JIT instead of a commission of inquiry? This is a twofold argument. Firstly, I draw your attention to PLD 2002 Lahore 78. There is
Again, Council, PLD
2002 Lahore 78. There is a judicial Lahore 78. Therein a judicial inquiry was made. I read out the operative. However, that even the judicial inquiry that was made, that did not affect the proceedings of the court. So, if at all they want to, even I am convinced of the fact that if some person is entrapped and he is innocent, he must be released forthwith. I am with the petitioners on this one. However, the question is that if a commission is made, that would not affect the trial by any means. So, if a JIT is made instead of a commission, the question would be that the report of JIT would be an investigative report. That report would be admissible before the trial court as a piece of evidence. The person who will make that report will come as a witness, and even in the cases where the accused is now convicted under section 428 CRPC, that report would be admissible in appeal as an additional evidence. Because commission at max, what a commission can do is give certain recommendations. They cannot primarily make the accused go free, or they cannot primarily give any other benefit to the accused. So if at all there is some accused who is facing a trial and he is innocent, I am all to the contention, because even the Holy Prophet has said in 99 गुनाहगार छूट गए, एक बेगुनाह को सजा ना. I'm all with that, but for that, GIT is the best possible solution so that a person is released in trial by all means and every means.
Thank you, Counsel.
So, because a commission, and lastly, if I may take a certain legal from the court and taking permission, a commission would make this issue more political than legal in essence. For the reason, back in 2017, a law was changed, a parliamentary committee was formed upon the fact that as to who has changed the law. The report of that parliamentary committee has yet to come.
Counsel, my question to you is, where do you draw a line between political and legal? I've been asking myself this question, especially in constitutional debates that end up in the Supreme Court, for instance, or before this court. In a lot of matters, they overlap so significantly that anything that is political has a legal implications, and anything that is legal held by the court has direct political ramifications. So I want to understand, when you say the commission's proceedings will make it political, but JIT proceedings will keep it legal.
Well, the difference that I can maybe for because I totally agree with your lordship that certain cases do have an overlapping of the legal framework and
Isn't this a major political controversy, whether the means and methods by which, as they claim, there are elements in the FIA which are able to manipulate the loopholes? That's their case. Isn't that as much a political question for the government of the day to get alerted to as it is a legal question of excess or abuse of authority?
I do in principle agree with your lordship. However, making distinction once again before your lordship, I would insist with honorable court on the point that if a commission is made, then that commission can only make certain recommendations.
That point I've already noted.
So those recommendations would be played politically, either on the law or
Every
on the working of
judgments of the court can be played on politically. Every observation of a judge in the court is played on politically. Every decision. So anyone who wants to get a political mileage out of anything.
But that political mileage would not help the accused who's facing a trial if a commission is made.
I am not exactly sure if what I am asked to do to direct the commission is solely to help the existing accused. This is a point that you must understand.
I mean,
Its remit is not to solely, it may have an indirect impact on that, but it is to, what they are asking this court to do, for the commission to do is, so that this doesn't recur in the future. Whatever loopholes are there are closed. This is, if I understand correctly, is what I am asked to do in this case.
however, even the recommendations of the GIT will be twofold. One, they will recommend if there is something like that, I am with everyone. मैं तो ये स्टेटमेंट बिल्कुल उर्दू में दूंगा कि अगर किसी ने गलत FIR में MD5 दर्ज करवा लिया तो he is basically the accused. Not the person facing the trial.
Thank you,
Last
counsel.
the report of the NCHR cannot also be relied for the reason it is against Section 18, provision of Section 18 of their Act.
You said 5 points, so now I have 6 to cover.
This is
Your
that I just bring up.
NCHR report.
Cannot be relied because the report of the NCHR is not in consonance with their basic statute.
Because it's contrary to Section 18.
But what I'm referring to the provision of Section 18, provided that, I'll read it out, provided that where A, it is necessary to inquire into the conduct of any person, or B, the reputation of any person is likely to be prejudicially affected by the inquiry, it shall, the word shall appears, give an opportunity to such person of being heard and produce evidence in his defense. Now, the report of the NCHR is silent with respect to this case.
Because the reputation of your client, of Mr.
Or the other person